Yes, Mr. Siegel.
My Lords, the last case addresses similar facts. It's the case of West. It's in your bundle at Authorities Bundle, page 80. If I can take you to 82, the summary. It's a decision Mr. Justice Langstaff had recently stepped down as President of the Employment Appeals Tribunal at that time. Could I just ask you to read to yourselves the first sort of 12 or so lines, ending with the bit that begins a line fleetingly brief as to be a person?
Yes.
Sorry, which page are we on?
82. 82, which is the official summary by the Employment Appeals Tribunal of its decision.
Yep.
Just to orient ourselves in terms of what the case was about.
Yes, this I had looked at before. Well, I suppose I can see why you want to take us to it, but it's like and unlike. That's the trouble with all actual cases.
You're right, of course, my Lord, but we say that the dissimilarities are a fortiori in favour of the employer. In that case, there was a policy, and it was obviously up for debate whether the claimant had been in obvious breach of that policy. Here, of course, not so. Paragraph 11 on page 86, it's recorded that there was a decision to dismiss, and then in the third line, the reasons for thinking the claimant's explanations were unsatisfactory, essentially concentrating on his awareness of the policy and rejecting the case that the employer thought the claimant had made, which, as he understood it according to the letter, was that he felt his duty of care to children outweighed the need to adhere to the policies. And then in the penultimate line, they noted that the conduct was plainly entirely open. This was something he was doing in front of others. Again, we say that leaving aside the policy point, that the point of comparison is clear, that in this case, the claimant had comforted a child in the way that he thought in his professional judgment was appropriate, and again had done so openly. And then at page 99, there's a highlighted passage towards the bottom of paragraph 34, beginning amongst the matters. If you could just read that to yourselves, please. And then perhaps within paragraph 35, the second sentence, the tribunal did not properly consider the terms of the policy. It did not ask clearly what the conduct was for which the claimant was dismissed. It doesn't add a great deal, I accept, but it does have some factual parallels. So stepping back, my Lords, we say in summary on this point, as a matter of principle, before turning to the tribunal judgment, that as the ACAS code and the case law makes clear, and the proposition I'm about to articulate, we say is obviously right, but my learned friend, I think, does not accept it, that in order to decide whether a dismissal for a single act of misconduct was within an employer's band of reasonable responses, a tribunal is required to identify whether the conduct was either conduct he had been warned might lead to dismissal, and I accept that can take different forms. It can be a disciplinary policy, it can be training, it can be written guidance, or conduct of a type that obviously might lead to dismissal without the need for such warning. And that obligation on the tribunal was not carried out by this tribunal. And we say that the respondent's attempts to rescue or circumvent that deficiency do not succeed. First, we point to something rather notable, to put it at its lowest, that in front of the appeal tribunal, we say that the respondent conceded that it did not regard the claimant's conduct as conduct for which he could expect to be dismissed. The most concise statement of that is within the core bundle at page 99.
Employer conceded that.
That the conduct in question was not conduct for which he could expect to be dismissed. So at core bundle page 99 at paragraph 78, you'll read...
Is this the... I think this is a statement Mr. Allen says is misunderstood.
Well, there's various formulations of it, and if it was a misunderstanding, it was certainly a fairly comprehensive and repetitive one, which rather suggests that there must have been some dialogue between bar and bench, which at the very lowest seems, on Mr. Allen's view, to have had something lost in translation. But certainly, as far as the Employment Appeals Tribunal was concerned, the respondent's stance was that it was not, by the emphasis in the original, the respondent's position that the original incident was in and of itself conduct which he could expect to be dismissed, but the claimant had been dismissed because of his subsequent attitude to it. Now, of course, I accept that in dismissing someone because of their attitude to conduct, obviously what the conduct was is a relevant consideration. I'm not suggesting that the two things bear no relation to each other. The same point is recorded several places elsewhere. At page 91 of the bundle, at paragraph 41 of the judgment, second sentence, the claimant's appeal was based on a false premise, Mr. Allen said, that he had been dismissed because of his conduct in the incident itself. The tribunal had found the respondent didn't have a no-touch policy. It was common ground this was not a safeguarding case. He said that it was never part of the respondent's case, that the claimant's conduct in the incident itself was ground for instant dismissal. What factually happened was not in dispute, etc. And then the next sentence, it was his failure to show any insight or awareness that led to his dismissal. At page 95, at paragraph 62, first sentence, submitted by the time of the disciplinary hearing, the issue was not what he'd done. So by the time of the disciplinary hearing, the issue was not what he claimed to have done, but his attitude to it. And finally, at page 104, at paragraph 96, we note again the contention that was the respondent's case, the claimant should appreciate that his conduct would be regarded as inappropriate, but he made clear that it was not the respondent's case. He should have appreciated that it was liable to result in dismissal. We say that it's a concession or whether it's simply a submission, either way, is rightly made in the sense that it is an acknowledgement of what we say is the obvious truth, that in the factual circumstances as found by the tribunal, namely what happened, what was or wasn't present by way of policy, guidance, etc., that it could not have been the case that the claimant realised or appreciated, as it's put there, that such conduct would render him liable to dismissal, at least for a first offence. But whatever the respondent may or may not have said, there's nothing in the reasons of the tribunal which addresses, let alone concludes, that the claimant was on notice, express or implicit, that such conduct might lead to his dismissal, which we say is presumably why these concessions were made and rightly made. And in passing, by the way...
Well, hang on 1 second.
I'm about to go to the judgment and the passages my learned friend relies on, so
all right.
that helps.
Okay, then I'll wait for you to do so.
I mean, it may be that my Lord has identified another passage, but in passing, I was going to say, just before we get there, we do reject the suggestion that it was in some sense impossible to draft any rule or guidance. And in fact, my learned friend pointed to something that one of the union officers had said, which includes the suggestion that guidance could and should be drafted. But such guidance is, I would venture to say, relatively routine. I don't know about Ofsted personally, I've never had no contact with Ofsted, but in general, in contexts involving potential safeguarding issues arising with children. And in respect of touch, and I'm not an expert in this, I don't pretend to be, but one could, for instance, have a policy that said you should not touch children unless it is appropriate in order to address injury or illness or avert a risk of harm to the child, which was in fact the evidence that Mr. Gafour was in practice what such a policy could and should have said. So now, my Lord, I turn to the passages my friend relies on at page 145 of the core bundle. I say relies on, it's mainly in the skeleton, but as opposed to this morning. Paragraph 73, which you were taking from. So it's acknowledged it's not a safeguarding issue, and then about 7 lines down, there's a line ending with I, and continuing, conclude that. I conclude that such an uninvited and unnecessary touch by an unknown adult to wipe away water from a child's forehead would cause any reasonable person who saw such an interaction to feel unease. The unbidden touch by an adult of an adolescent and young child by a stranger in this day and age would be seen as not appropriate and might be considered to be a misuse of power which violates the child's right to be treated with dignity. But those observations, even if they are correct, clearly do not equate to a factual finding that it was inherently obvious that such conduct might lead to dismissal, let alone a one-off instance of such conduct. Indeed, as you know, the relevantly qualified Lado, who had sight of the pupil's written complaint, you'll recall the only evidence about what happened was that handwritten complaint of the pupil and, of course, the claimant's evidence to the disciplinary hearing and appeal hearing in particular. So the relevant Lado had sight of that, and you will recall the view taken by that relevantly qualified person. The respondent also places some reliance at 146, the next page, on paragraph 79.
Just one moment. What is your submission on whether as far as it goes, and I do take your point that it's not the same as saying that the reasonable person would think it was a dismissible offence, but as far as it goes, is this a finding with which the EAT was entitled to disagree? Well, perhaps more accurately, it's obviously entitled to disagree with it if it thinks it's perverse. Is it clear that it did disagree with it?
I'm not sure that it did. And my Lord will recall from a recent hearing, I'm always a little nervous about the use of the word finding, which sometimes covers a multitude of sins. A factual finding about what happened or what a state of affairs was is one category of finding. This is, I would respectfully suggest, a person's more or less educated or expert view about something. I wouldn't myself refer to it as a finding, but the point I make is you could substitute, let's take an example. In the workplace, someone tells a joke that 20 years ago would have been entirely unremarkable and unobjectionable, but now has a sort of loaded connotation of, let's say, misogyny, or it's about an Irishman or something, I don't know. It's now not acceptable, it's inappropriate, and it would cause unease. Now, if there was a policy that said anybody using flippant language that has any connotation of sexism or racism will be dismissed summarily, a very, very unusual workplace, but fair enough. But without such a policy, the fact that it might be considered inappropriate or put some people at unease may be true, but it's a gulf away from putting employees on notice that it's going to be a cause for instant dismissal.
As far as the status of this passage is concerned, might it be categorised as a conclusion, to avoid the word finding, about community standards generally? Drawn either, which would have to be drawn either from evidence or from as a matter of judicial notice.
I think it's the latter.
There's no other source of it, is there?
One sees immediately before the occasion for it.
It can't be a matter of personal opinion, because it's got to be the person on the Clapham omnibus, which is the,
Exactly.
the archetypal reasonable person.
And unfortunately, judges, like the rest of us, and I am a part-time judge as well, so tar myself with the same brush, we all tend to think we're reasonable people.
I want you to know I do travel on the 87 bus.
Well, I travel on many buses and occasionally to Clapham, but not regularly. So, yes, I think my lord must be entirely right. It is someone attempting to tap into the zeitgeist.
See, I've had occasion to, this comes up quite a lot in defamation, where one
Yes.
has to apply community standards, and we're always very careful not to try to avoid bringing our own standards to bear. But if an appeal tribunal looks at this and says, well, I don't agree with that, so it can't be a universal view, and that's the only view that matters,
Well,
then would the appeal tribunal be entitled to say, well, that's not a legitimate finding, whether it's perverse or not may not be the test.
well, I think so. Let's put it into the context of this case. If instead of saying what she had said, the judge had said, I deem it obvious that in 2021, or whenever this incident was, it should have been obvious to anybody in that environment that what they did was going to be categorised as gross misconduct, might lead to instant dismissal. Had she said that, that would, on its face, have entitled her to uphold the dismissal. Then you ask me, my lord, what would the appeal tribunal's function be in that situation? And I, against myself, I would tend to err on the side of caution and say only if the Employment Appeal Tribunal felt that that finding was not one to which a reasonable employment tribunal judge properly directing herself could come, would it be entitled to interfere? Now, that's almost identical to a perversity test, maybe is a perversity test, but that, I think, is right for me to concede. If that had been the finding, then the limit of the Employment Appeal Tribunal. Now, in this case, in fact, it's clear that
You
is
don't
what
need to go there, you say.
Yeah, I mean, you avoid all these
Yeah.
things by saying you have to look quite carefully at what she said. She does say, of course, any reasonable person to feel unease. You say fine, but that's very different from dismissal. The second sentence doesn't quite go so far as to say any reasonable person, or perhaps glosses what they mean by unease, because it says be seen as, well, I see, would be seen as not appropriate. That must be would be seen by any reasonable person.
I agree.
But then the second half is more nuanced. Might be considered to be a misuse of power which violates the child's right to be treated with dignity. I mean, frankly, I mean no disrespect to the employment judge. I doubt whether she was carefully,
Of course.
using her tenses in each of those.
I mean,
But the fundamental point is what sort of unease, and that feeds into whether it's the sort of thing that would expect you to be dismissed.
and I have to say, for what it's worth, as someone who has occasionally travelled on the Clapham omnibus, that even in 2024, the proposition that the unbidden touch by an adult of an adolescent or young child by a stranger in this day and age would, i.e. would always, be seen as not appropriate and moreover, etc., etc. I personally find that an extraordinary proposition.
Don't we also need to be careful about what's actually meant in this context by an unknown adult or a stranger? I mean, if one saw this incident take place on the Clapham omnibus itself, one would be very likely disconcerted to see a complete stranger stand up and do this to a child sitting nearby on the bus. But this is an entirely different context where your client he's known to be a member of the inspectorate who is coming to the school, and in that sense he's well known. It's just his name and identity are not known to the child. But his presence there is totally explicable. And one might well expect some kind of social interaction, if nothing more, when you're faced with the entirely unusual and unexpected scenario of being confronted with a whole group of dripping children coming in from the rain.
Yeah, and this, I would gratefully adopt that more important part of the context. There's also another important part of the context, which is this is not in the street.
No, quite.
This is in a school context where responsible adults, teachers, other children are around. So certainly in context, I would say that the judgment or conclusion of the tribunal judge goes too far even on its face, but what it doesn't possibly do is equate, as I say, to a finding that Mr. Hewston should have anticipated that that one event might lead to his instant dismissal. As indeed the relevantly qualified Lado did not think, and the members of the Employment Appeals Tribunal did not think. The other passage, to be fair to the respondent, was on the next page at paragraph 79. The claimant was aware of the rules and guidelines, and the claimant's actions were found to fall short of the standards and expectations of the respondent. Well, the latter is unexceptionable. That's what the dismissal says. We find you guilty of not complying with the guidance. But what are the rules of guidance or standards and expectations? They're that extract from the Social Care Common Inspection Framework. And given that it's common ground that this conduct didn't involve a safeguarding issue, then the rule or guidance simply begs the question whether the sort of touch that the claimant momentarily made was outside of Ofsted values or involved not treating the student with respect and sensitivity. I mean, he clearly thought it was, and in no way implies, as I say, that a single instance of the actual conduct might lead to his dismissal. So given that the tribunal didn't make necessary finding, these grounds of appeal must be dismissed unless this court considers that the only proper conclusion on the primary facts found by the tribunal is that it should have been obvious to the claimant that his conduct might lead him to be dismissed. I accept that if that is the case, this court is in theory entitled to say the appeal tribunal was completely wrong. The employment judge may or may not have got her analysis right, but it doesn't matter, because if she had applied her mind to it, she's bound to come up with that conclusion. However, that would be literally a remarkable conclusion, because we know that the qualified Lado didn't take that view. We know that two former Ofsted inspectors who gave evidence in claimant support at the tribunal didn't take that view. And we know that the three members of the employment appeal on the facts found by the tribunal, including a member who's expert in the field of child protection, did not think so. And that, we say, does apply or calls for the application of the adage of QED. It is sufficient to demonstrate that it cannot sensibly be said that it should have been obvious that his conduct might lead to him being dismissed. And one small point here, my learned friend sought to distance the judge and her understanding after what he said was a greater degree of evidence about what had happened from that of the Lado, which he said, who he said had reached a view at an earlier stage and without all the same evidence. But I don't know what this evidence is supposed to be. The only evidence in this case is the child's complaint, Mr. Hewston's evidence, and if you think it relevant, the social care guidelines. And in fact, we say it's not a valid point anywhere. If you go to the core bundle at page 146, which you may still be on, at paragraph 78, the judge rather associates herself with the view taken by the Lado. Whilst I and the Lado may consider that a sanction failing short of dismissal may be appropriate and further training might be given, it's not for me to substitute, and that's where she goes wrong. She does undertake a procedural box ticking exercise. exercise. Did they have an investigation? Yes. Did they go through the right procedures, disciplinary hearing? We say no. She said yes. It's down to them. I can't interfere. That's to abdicate her responsibility in precisely the way that Lord Justice Boone cautions against.
And so what's missing is the standing back and looking at the matter as a matter of equity and general merits, which is what the statute requires, after all.
Well, I'm itching to invite a court of this august constitution to be one of the voices. There has been one or two others that at least points to the possible pitfalls of the reasonable range of responses.
Well, it's
approach.
part of the exercise, but it's not the entirety of it.
Yes.
I mean, that if my lord, as I've already indicated, I'm keen on sticking to the words of 98.4 on the very glosses. More specifically on the question of the effect of equity in the general merits of the case, I've got a feeling that there have been courts of quite high authority that have slightly said those don't add much. But I haven't looked at this for a long time. Are you aware what those authorities are?
Not off the top of my head.
But I mean, the sort of line I think they take is that's all very well and is a helpful sort of background to it all, but we've got to have some rules here.
I mean, what I would say is that if you just look at the statute, and I'm a great fan of just looking at the statute and construing it,
yes.
What it is asking a tribunal, what is requiring a tribunal to do, is to make the decision whether the employer acted reasonably in treating the reason sufficient to dismiss, taking into account in the tribunal making that decision, the equity and substantial merits of the case. So the tribunal might determine that it was reasonable to treat a man throwing a cigarette butt over his shoulder without care as a reason justifying dismissal if he was working in a petroleum factory, but not if he was working in a builder's yard. So I think that's my understanding, at least, of what those add. You must take into account all the relevant circumstances and reach a judgment, as my lord says, that ultimately is an equitable one. I should address the Swag-Uribe case that my learned friend relied on.
And just before you get that, I don't think the case is in to turn on this, but if the juniors are not too busy taking a note, they can perhaps just have a quick look to see whether there is authority on the question of what the phrase to which my lord attached understandable importance really amounts to in real life.
Of course.
And if you look in the Q section of Harvey, you may find it.
Thank you. The case is at page 14. It involved a case, my learned friend slightly undersold the fact. The claimant was a branch manager, had failed to follow two written processes on two separate occasions in two separate respects. One was for issuing large amounts of cash, which my learned friend pointed to, which resulted in a fraud on the bank, but also failed to follow written procedures in relation to the authorisation of a loan, despite having adequate training and experience. And if one goes within that judgment to page 27, one sees within paragraph 34, the highlighted passage, the tribunal noted that the claimant had acknowledged that she had received adequate training and had previous banking experience and admitted she had not followed the LPP process. It was an oversight and it was wrong, and acknowledged she knew she was not authorised to sign the loan approval. So this really is deliberate wrongdoing or reckless negligence. But the critical, and I should say, by the way, that if one goes quickly to page 90, do I mean 90? I'm sure I think I've missed the number in, just bear with me one moment. It's paragraph 96. I suspect I should have said 50, but yes, it's page 50. it's clear from the tribunal's findings, top paragraph, and indeed the admissions of the claimant she'd received adequate training and as a senior employee was perfectly well aware of the proper procedures, both for the LPP and authorisation of loans. The fact that there may have been no specific training was therefore irrelevant, notwithstanding the claimant accepted she had been adequately trained and not followed proper procedures. So a pretty extreme case. But the critical finding is a few pages up at paragraph 43. Page 30. At the very bottom of the last page, you have at paragraph 45, the Employment Tribunal was satisfied that the claimant's conduct in relation to the authorisation of the loan and the LPP amounted to gross misconduct. And then the print that was hard to read earlier, Tribunal note that bearing in mind the claimant's previous banking experience and seniority, she would be expected to know the failure to properly complete the form and to sign the loan. In particular, to sign the loan without proper authorisation must be regarded as a serious breach of the rules and procedures and accepted standards of conduct and could result in her losing trust of her employer. And that is repeated, that's the Employment Tribunal being quoted. One goes to page 49 at paragraph 93. One sees that the Appeal Tribunal, and my learned friend took you to 94, but you need to read 93 because 94 and what follows are particulars of or explanations of the finding at 93. So under the heading conclusions, third sentence, it is crucial to bear in mind that the Employment Tribunal found specifically, both in relation to the LPP and authorised loans, that the respondent was entitled to treat the claimant's conduct as gross misconduct. And what follows are simply the reasons why that was approved. And the first my learned friend read was a senior employee should have been aware of gravity in those circumstances unnecessary to specify, to specifically warn her, of the consequences of what she already knew, or should have probably have known that the respondent would regard her breaches of duty as serious. So in short, in that case, the tribunal made an express finding which was upheld on appeal, that given the written policies, the claimant's experience and knowledge of them, and the training, she was, in fact, she admitted she was, but in any event was or should have been, aware that her conduct in failing to follow those procedures might lead to her dismissal. By contrast, in the present case, of course, as you know, no written procedures, no relevant training, and we say the judge could not reasonably have found, but more to the point, did not find that the claimant was or should have been aware that his conduct was of the sort that might lead to his dismissal. There's another authority that I would respectfully suggest assists. It's at page 56, so I think it's the next authority as it happens. The authority of Tyler. Decision of this court. It's another example of the Employment Appeal Tribunal overturning a decision made by an Employment Tribunal, whether the claimant's dismissal had been within the band of reasonable responses, and substituting its own contrary decision, as here, and in this case of the Court of Appeal upholding that decision. And the case illustrates again how critical it is for a tribunal to consider whether the employer identifies a particular type of conduct as potentially justifying dismissal for a first offence. If I start at the head note on the next page 57, under the words the Court of Appeal held, the tribunal had erred in finding that Ms. Taille's dismissal had not been within the band of reasonable responses. Bottom of the same long paragraph, the Appeal Tribunal had been right to conclude that the decision of the tribunal as to the unfairness of the dismissal could not have stood. And then in the next, under observed, second paragraph, whether or not a dismissal falls within the band of reasonable responses is either a finding of fact, pure and simple, or else a finding in the nature of a value judgment, echoing the exchange between myself and Professor Warby, akin to such a finding. Whichever it is, once the tribunal makes its finding, that normally marks the end of the matter, and then top of the next page, column, top of the next column, same page. The only bases on which appellate challenges to tribunal's findings of fact will be permitted by the Appeal Tribunal will be if they are said to have been supported by no evidence, or they were findings that no reasonable tribunal could have reached. In either case, if such challenges are made good, they will demonstrate an error of law. And that, obviously, the latter of those is this case, according to the Employment Appeals Tribunal and to the claimant. And then at paragraph 7, on page 58, we don't need to read all of this, but at the beginning, it was common ground or found that the employee handbook was incorporated into her contract. A few lines down, the list against 28 bullet points of conduct that would be deemed gross misconduct. So this was the good employer who set out the warnings, as it were. And you'll note at 15 and 16, falsification of timesheets, which didn't apply in this case, and falsification of written records, including, this was a care home medical record of the company. So in this case, the relevant offence, the claimant had falsified medical records, had been expressly identified in a written procedure as an example of what the employer would treat as gross misconduct. And the primary error in the tribunal's approach is set out at page 62. Paragraph 38. If I can pick it up halfway down that paragraph, there's a sentence beginning in the middle of the line. The EAT said in paragraph 43 that it regarded this as clearest when the tribunal's finding that the basis for the charge, falsification of the written records of the company, was, as the tribunal had said, in a different category of seriousness from the types of gross misconduct which appear above and below. The appeal tribunal's view was that there was no warrant for that conclusion in the list itself, and the tribunal regarded it as unjustified. And then you've got the highlighted part, skipping a few lines. It's entitled to expect that professional nursing staff will complete these medical records accurately, and there will be a record of treatment given. To make an entry deliberately in a fluid chart where no fluid is given is to make a false record, etc., etc. And then I think next, if we go to page 65, 3 pages down, at the top of the second column, so there's a highlighted, sidebarred passage. There's a new sentence beginning near the top of the...
So which page are we on?
Sorry, my lord, 65. It's within paragraph 59. So second column of the page.
Yes, yeah.
The handbook explains to employees that the employer will regard the following list as gross misconduct, leading to summary dismissal. Tribunal's view that item 16 was in a different category was that in some unexplained way, falsification of company records was inherently less serious than, for example, timesheets. In my view, that view was an error of law. Skip a few lines. In principle, however, the falsification of written records is, for obvious reasons, a serious.
Sorry, if I know how much you were going to read, should we just not read? How much should we not read it to ourselves?
Just all right, then, just to the end of that paragraph,
all right,
the whole of the sidebar.
Yes.
And just note the repeated use of the word obvious in the assessment of the Court of Appeal. It's obvious that deliberately falsifying medical records was conduct which might well merit dismissal. In that case, of course, the employer had also identified it as such. And that's the same yardstick adopted by the Employment Appeals Tribunal in this case. I won't take you to it, but see, for example, paragraph 74 of its judgment. And that's the correct yardstick. It's got to be obvious if it's not. This case was belt and braces. It was both obvious and pre-warned. But if not pre-warned, it must be obvious, though the application yields the opposite result here. And it was in that context that, in a passage that my learned friend quoted, I think in his skeleton, 65, towards the bottom of page 66, the Court of Appeal held, 6 lines down, the ET's error was to substitute its own subjective view that such falsification is not as serious as other offences listed in the handbook, list in place of the employer's apparently different view as to the seriousness of the offence being one that merited dismissal. But of course that doesn't help the respondent in this case at all, because what they're talking about here is the employer having made that judgment and recorded it in the disciplinary policy, which was made available to the claimant. Two other short points by reference to this judgment. If you go back to 64 on the previous page, do I mean 64? Sorry, I mean page 64, my mistake. If you go to page 64, you will see at the top of the second column, just above paragraph 52, the tribunal held that dismissal did not fall within the band of reasonable responses, whereas, also in the case of each, the appeal tribunal held that it did. Given the difference between the two tribunals below, there was some discussion before us as to what this court's role is in such a case. In this context, it's to be noted first that just as the ET wing members will have experience from both sides of industry, so likewise will the AT wing members, so that each tribunal will bring to bear the like industrial experience. Then the last sentence of the paragraph, there's no doubt that the so-called lay members of the EAT make an invaluable contribution to its decision-making process, as I found from my own experience of sitting in the EAT, as I'm sure my lord did also. Now, why do I bother with that? Because in a point I was hoping would be cleverly made that my junior had fed me, but which my lord had already spotted. In the appeal tribunal in this case, two lay members and a judge. One of the lay members was Professor Andrew Rowland, who's an officer for child protection at the Royal College of Paediatrics and Childcare, and whose participation in the appeal was expressly agreed by the parties when it was very properly raised. Whereas the judge, through no fault of her own, government cuts, was deprived of lay members and had to make the decision her own. And then at page 66, paragraph 69, so we're at the bottom of page 66, but this time in the second column, the last few lines of the page, the remaining issue is whether, having arrived at that conclusion, the only course properly open to the appeal tribunal was to remit, as to whether, on the facts of the case, the dismissal, etc., etc. Mr. Clark's submission was this was the only course he could properly adopt, as the respondent argues here. That is because the question is one of fact. And it is the
well, again, we can read this to ourselves. It's on into 70, isn't it?
Yes, if you would, just to the sort of first two-thirds of 70,
yeah,
down to the line ending, or raising questions which there's only one answer about.
Yeah, well, it's pre-Jaffrey, just, but it uses the same test, only one answer.
We say so, yes. So in truth, my lords, the first two grounds of appeal are simply a misconceived attempt to avoid the application of a very well established, as the editors of Harvey would put it, venerable principle of good employment practice and law, that an employee must be on fair notice, either express or because it's obvious that a single instance of the conduct in question might lead to dismissal, and that being so, this appeal must be dismissed. I now turn to the issue of attitude, ground 3, which focuses on the claimant's supposed attitude to his conduct during the disciplinary process. We say it's simply another attempt to avoid the consequence of that venerable principle, in effect by seeking to substitute as the reason for dismissal his attitude. And may I make this preliminary point, because in light of my learned friend's oral submissions, it's an important one for us to bear in mind. In general, if an employer has a written disciplinary policy, it will usually subdivide it in the way that you've seen in the Taillé case, for instance, so that you have a non-exhaustive list of offences that will merit a warning, let's say, and a separate list, again, non-exhaustive usually, of offences that will constitute gross misconduct and therefore might lead, not will automatically lead, but might lead to dismissal. And if an employee commits an offence of the less serious sort, that is said would lead to a warning, or if they've already had one warning, perhaps a final warning, the employee will not be charged with gross misconduct and is not liable for dismissal, and their attitude to whether they did anything wrong cannot conceivably translate the, unless their attitude is exhibited in a way which of itself constitutes serious misconduct if they grab the dismissing officer by the throat.
Well, I'm not sure that's right. Is it? Suppose, of course, you would say this was, in fact, in all circumstances, not a very serious conduct. But suppose you have a case where really quite trivial misconduct is the subject of proceedings, and the question then is, do we give a warning or do we give a final warning? No question of it being gross misconduct. In deciding whether to give a warning or a final warning, you might take into account the fact that the person...
We're at cross purposes. I agree with my lord entirely.
Oh, I see.
What I meant
I misunderstood what you meant.
No, it's my fault. What I meant was it can't translate it from category 1A or 1B to category 2. It can't translate it into a dismissible offence.
Yes, I see.
And taking into account the concessions rightly made, and even if they're not concessions or weren't made at all, we say that is the situation. Namely, he couldn't have legitimately been dismissed purely for his conduct. That should be the end of the matter. But my learned friend's nuanced point this morning, which was you could have an offence that was not gross misconduct, but which, coupled with the attitude during the disciplinary process, elevated it to something equivalent to, is purely theoretical. It's not this case. In this case, can I invite you back to supplementary bundle, page 40? I think I've finally realised that page 40 and page 41 are duplicates. So we've been talking about the dismissal letter beginning at 40. So I just use that in case you've been making notes. The charges were 1, 2, 3, 4. You see them set out. And then underneath, you've been informed that the above allegations, if proven, could constitute gross misconduct for which you could be dismissed. And then over a series of a number of pages, the dismissing officer goes through each of the charges and says at the end, I paraphrase, I find this proven. And then, interestingly, if you go to page 46, which my learned friend took you to, having concluded that all these charges of gross misconduct were proven, there's a heading, further mitigation. And under that heading, in the third paragraph, I've considered the mitigation we put forward, in order to save time, bear that in mind, it's relevant to a later point. That's all that the dismissal letter says. So it doesn't say, you put forward as mitigation A, B, C, D, we rejected A and B, we didn't like C and D.
Sorry to interrupt. It's not quite right. I think at the first page of the letter, there's a reference to a 6-page appendix, which we don't have in this court, but which set out all of the mitigation.
Oh.
No, I'm sorry. I
thought you were suggesting that that was the only thing.
No. If I implied that they didn't know what the mitigation was, then I certainly didn't mean that. It's on the face of the record of the disciplinary hearing
But
itself.
sorry, can we just track that down? And it's not likely to be important, but factually, I hadn't spotted that. I know you were speaking off the cuff, Mr. Allen. I don't think it's on the first page.
Go on.
We're talking about the dismissal letter.
Yes. Sorry, it's at page 46. It says, I've detailed these in the enclosed appendices. I think I'm not sure about my 6 pages, but it may be that I have simply a recollection of them being 6 pages.
No, I'm great. As I say, there's nothing between us. I don't.
Well, it's just so that I know. I assumed the appendices were appendices to the investigation report.
No, I think
You're saying there was an appendix containing mitigation. Have I got lost?
No, I think there was an appendix containing mitigation. This is
An appendix to what?
It was something that it's an appendix to this letter, but it was something that the claimant handed in during the process. I'm going to try and see if I can find a reference to it in the disciplinary meeting.
I see. Sorry. Yes, it's page 46. Perhaps that's what you said. I was looking at
Yes.
the first page.
I was wrong about the first page, sorry.
I have detailed these in the enclosed appendices. So these are not the appendices to the investigation report. These are some different appendices to the letter, which we haven't got.
And which I've just been shown because my learned junior, who was at the hearings below, as you know, has them in a different place, and they refer to what I wouldn't personally necessarily call mitigation as aspects of defence, why it shouldn't be looked at as a gross misconduct offence, effectively.
I mean, it's slightly odd that the reference at the end of the letter to the enclosures doesn't actually refer to the enclosed appendices.
There's another reference within the materials that we do have at page 112 of the supplementary bundle, which is within the witness statement of the dismissing officer. And she says, for Andrew's reference, I also included a 3-page, sorry about the 6-page, a 3-page appendix to the outcome letter, which included my review of his further mitigation arguments. And then she makes reference to pages within the Employment Tribunal bundle, which I will have I'm sure I've got.
Well, I'm not terribly keen to have fresh documents. Clearly no one thought we needed, so I'm not inviting you to provide them, but I'm inviting, as long as neither of you think we need to see them, that's fine. Okay?
I'm really sorry to have interrupted so
No,
much.
you did the right thing.
It was just that I thought it was being said that there was no mention of mitigation, and there was actually this appendix which mentioned mitigation. That was really all I was saying.
Well, no, you were right to intervene, and we're now clear on what the position is, though we don't know the details. Yep.
But the point which I was making, which may or may not have already become clear, is that this was a case where the employer itself said, what you have done, never mind your attitude to it subsequently, which they didn't know about obviously yet because it was at the charging stage, what you have done is gross misconduct and might lead to your dismissal. They then found each of the charges proved, and then they had to decide for themselves, I accept, do we actually dismiss? We're entitled to, it's gross misconduct. We found all the charges proved. There might be mitigation, which would encourage them to impose a lesser sanction, and they decide not to. That is not the case of the type that my learned friend hypothesised this morning. And it's unclear, as I stand here now still, whether the respondent accepts.
Sorry, it must be the time of the afternoon. I don't quite understand I don't really understand what the issue you're addressing is. If an act which is potentially an act of gross misconduct is found proved, I thought this is under the general heading of attitude rather than mitigation.
Yes.
Mr. Allen's proposition was that the employer might take the view this is gross misconduct. It's sufficiently serious for dismissal to be in the frame. If he had shown he had a full understanding of the implications of what he'd done and was thus less likely to do it again, we would not dismiss. But since he hasn't done that, we will dismiss. Now, in one sense, therefore, the decision to dismiss, part of the reason for that is the lack of insight. To me, that seems a perfectly sensible analysis, though it's not part of the reason for the dismissal in another sense. But the reason for the dismissal is the conduct.
My lord, it's impeccable, that analysis, but it isn't the one that the respondent is advancing. The respondent's case, both to the Employment Appeals Tribunal and to this court this morning, was, to the Employment Appeals Tribunal, it was sort of honed in on the facts of this case. To yourselves, it was more a hypothetical answer to one of my lord's questions. But their case is, you can have an offence that is not, on any view, gross misconduct. So, you know, the person who, instead of sharpening a new pencil, throws the barely used old one in the bin, grabs a new one. That's not an offence of gross misconduct on any view. If they come to be tasked with it at a disciplinary process and say, well, it's ridiculous that I'm even here. And even if they were to go on to say, and the next time I have a pencil that's worn down a bit, I'm going to grab a new one. Unless that constitutes a fresh act of insubordination, thus gross misconduct, they can't be dismissed for it. And the point I'm making, and it's not controversial, is that this employer, throughout the whole process, styled Mr. Hewston's conduct as gross misconduct, and in every respect found it proven. So then, as my Lord says, the only question is there sufficient mitigation to warrant a lesser penalty than dismissal? And we still don't know whether the respondent accepts what we say is the obvious proposition. We think it doesn't. That if a single act by an employee cannot reasonably be said to constitute gross misconduct, this case, then the employee's reaction to being charged with gross misconduct in respect of that act cannot transform what would be an unfair dismissal into a fair one.
Yes, I see.
Yeah.
No, well, I had understood that to be
Yeah.
your point. I didn't realise it was the point you were on here.
And
And that does seem to be a logically sensible position, if I may say so, because and it carries with it the implication that you can't, something which is not inherently gross taken by itself can't be turned into it just by your attitude to what is ex hypothesi not a charge of gross misconduct.
and as we styled it by reference to a famous novel, which my Lord Justice Underhill also put to my learned friend, otherwise you really are in a catch-22 situation, because the more trivial your
I
conduct,
rather regret using catchphrases. It's become such a cliche, but still.
it's a good one. I can't think of an alternative. The more trivial the conduct, the more likely you are to protest that it's not gross misconduct. I did not commit an act of grave misconduct. And then be criticised, if you go, for instance, to the reliance by the tribunal at page 142 of the core bundle, at paragraph 57, on the relevant part of, so I'm doing two things at once here. I'm showing you what was in the dismissal letter and that the tribunal relied on it. If you go to the bottom of the indented italicised paragraph, more pertinent, I have no confidence in you sufficiently understanding the severity of your error. So you'll be criticised for not sufficiently understanding the severity of your error. Whereas, of course, if you accept that your error was severe, the employer says, well, there's nothing between us. This was gross misconduct. And the law is not such an ass. Where the employer is charged with gross misconduct, as here, for an act that he believed, at the time at least, did not warrant that characterisation, his proper course, not least his ethical course, because it's the only way to tell the truth, is to say so. But to acknowledge that if the employer intends to treat such conduct as serious in the future, then he will not repeat it. In that sense, the disciplinary process serves as a substitute for prior warning, as of course does, for instance, a final written warning. If you do this again, you will be dismissed. And that's exactly what, contrary to the respondent's attempt to suggest otherwise, the claimant did in this case. Can I take you to 140, a couple of pages up? Sorry, my heart sank. I thought my learned junior was expecting me to interpose a little note that comprised an entire page, but it's actually his answer to my Lord's question about substantial merits and the equity of the case.
Oh, I
Deal
see.
with it
Well,
later.
at an appropriate time, but not now.
I thought, I'm not going to be able to read that little So
I'll tell you what, as a punishment, you can make him deal with it at the end of your submission.
that is an excellent idea, my Lord. If you go to paragraph 48 of the tribunal's decision, this is the bit that the tribunal relied on. We'll deal with what else was said during this mini process in the italicised words, which you've already read and which have been read out to you. Where he says, I would not do it again. His position was explained both at the disciplinary and the appeal stage. If you go to the supplementary bundle, the disciplinary, my learned friend took you to page 22. which is notes of my learned friend's cross-examination. And at the next page, 23, you see at the bottom my learned friend's question. You say it was appropriate. Do you still say today that it was wholly appropriate? And he says, as my learned friend read out, at this point, I know, in other words, when I did it, I was unaware of Gaffar's viewpoint that touch should only be made in exceptional circumstances. There's been numerous training put on, including a conference where touch was put forward as a positive way of engaging. The respondent has, insert the word now, put forward that this was only for social workers, but that wasn't made clear. Would I do it now? No. And then over the page, my learned friend says, at the end of his next question, your position at the time was it wasn't inappropriate. And he replies, that's what's written. There's an even fuller...
Sorry, wait a moment. Over the page, where were you looking?
Sorry, it's the last few words of the first question on page 24.
Yes, I see. Not that it matters, just so I can get it clear.
Yep.
And this is actually not the next question. It seems there's a...
Oh, sorry.
He's obviously come back to the subject the
You're
next
quite
day.
right. The next recorded question, I should have said.
Yeah, that's fine.
And I do take you to the appeal because my learned friend placed some reliance on the decision of the appeal officer. Can I ask you to go to page 87? These are the written grounds of appeal. And could I invite you to read the 2 paragraphs in the bottom half of the page beginning the complaint raised against me, that paragraph and the next. When you finish that, go over the page and read the first new paragraph on the next page, beginning, I will take on this guidance.
Yeah.
So, having read that, you may perhaps, like me, find that the decision of Mr. Simmons, the appeal officer, as summarised in the paragraph of the tribunal judgment to which my learned friend took you, which is paragraph 69 at page 144, that he could have no confidence that Mr. Hewston, as it were, had learnt the lesson, seems, well, I am afraid I'm going to put it pretty high, inexplicable.
Sorry, which page are we on now?
Just, it was a reference really, but my learned friend's already taken you to it. It's ET 69, page 144 of the core button. He couldn't be relied on to exercise the relevant professional judgment.
Oh, I see. Sorry, I was looking for one thing. Yep.
And what both the what both the disciplinary officer and the appeal officer do, and what, to a lesser extent, I regret to say that the respondent does, is to confuse 2 different questions. What did you think at the time? I've seen that, inter alia supplementary bundle pages 23 to 24 that I've just looked at. Namely, I thought I was showing care. I thought I'd been trained in a way that made that acceptable. I thought it was acceptable. I thought it wasn't inappropriate. And my learned friend tries to fix him with that as though that's something wrong. That's just stating a fact. At the time, I thought it was not inappropriate. I think one of my lords said if he thought it was inappropriate at the time, he wouldn't have done it. Confusing that question with what will your actions be in the future? And it's not, as you read from these passages in both the disciplinary hearing and the appeal, it's not that he's saying, as my Lord Justice Henderson says, this isn't going to happen again, exactly the same situation. He's not saying, if a 12-year-old child with wet hair comes in, I won't touch his forehead. He's making it quite clear. He now understands that they're saying what I thought was okay, namely touch in order to show care, is not okay. And I won't do that again. And to criticise him for stating his view that until he'd been told that the conduct in question was taken so seriously, he'd not shared his employer's view as to the severity of his error, that criticism can only be fair on the premise that his conduct was obviously so serious as to render him liable for dismissal, even in the absence of procedures or training identifying it as such. And that premise, for reasons given, is false. And we say, the Employment Tribunal, I've tried to avoid too much reference to their judgment, but we say they put it very well at page 100 of the core bundle. Paragraph 81. If you'd read, please, well, it's easier actually, but it's not that much. From the third line in 81, if the deciding manager is satisfied the employee has shown insight, remorse and a willingness to learn, they may take the view that in light of this, the sanction should be less than it otherwise might have been. Conversely, where these features are not present, they may feel unable or unwilling to reduce the sanction on that account. But it would not, in the given case, be open to the employer within the band of reasonable responses to dismiss for the substantive conduct. The absence of such features cannot render that sanction fair. And that, we say, ought to be trumped. And in the present case, we say that the respondent has belatedly appreciated the difficulty it has in supporting the judge's decision on the basis that the claimant knew or ought to have known that his conduct might lead to his dismissal, and has therefore tried to shift the emphasis away from the conduct itself towards the supposed inappropriate attitude, to the extent that, as I say, they sought to persuade the appeal tribunal that that was the primary reason for his dismissal. But that's an attempt to rewrite history, as we saw from the dismissal letter. But in any event, the tribunal, this is my last point on this, on the facts of this, the tribunal clearly understood the dismissal to have been for the act of what it recorded as summary gross misconduct. If you go to page 141 of the court, looking it up within the conclusions of paragraph 52, the dismissing officer, Ms. Fitzjohn, informed the claimant, confirmed the outcome. He was dismissed for summary gross misconduct. 53. Following the disciplinary hearing, they wrote to him, terminating his employment without notice for gross misconduct, concluded that the claimant had failed to exercise good inspection judgment by initiating physical contact with a student where it was not invited or expected, and then the italicized words underneath are worth looking at. You may have been trying to convey a feeling of trust, etc., but that was a grave error of judgment on your part. And then, if you go to page 145, within the more sort of point-by-point summary of the judge heads it argument and conclusions, but at 74 on that page, it is clear that the reason for the claimant's dismissal was the claimant's conduct. And then what we say is a bit of a tick box exercise. They followed a process in accordance with their procedure. And then over the page, 75, sorry, not 75, beg your pardon, 76. In light of the findings I've made, I conclude the respondent's reason to dismiss was misconduct and gross misconduct, and in particular that the claimant's actions undermined the trust and confidence. 77. Respondent took the decision to dismiss after a fair and reasonable investigation which founded their belief that the claimant's actions amounted to gross misconduct. And that was the reason for his dismissal. 80. Last two lines. The claimant was dismissed for reasons of gross misconduct. 82, finally. The claimant's dismissal was such he was found to be guilty of gross misconduct. Reached the essential terms of his contract.
I'm sorry, I got lost. Why are we being shown all these passages?
Because there is no question that the tribunal, just as the respondent's own officers, dismissed Mr. Hewston because they concluded he had been guilty.
Sorry, can you speak up a little?
He had been guilty of gross misconduct.
I think on your submission, it would have been perverse to do otherwise, because it's so clear on the face of the documents that you've shown us.
Correct.
That was the reason for dismissal.
Correct.
I think what you're saying is that the dismissal was premised on the conduct specified in the full charges amounting to gross misconduct.
Yes.
And then that the mitigation was dismissed on the basis that the claimant of the employee had wrongly taken issue with the proposition that what he'd done was gross misconduct.
Yeah, it was.
So it's a double whammy, if I can change the metaphor.
Yes, I mean,
Not so literary.
Yes, at least double. There's a case that was referred to my learned friend Skeleton. I don't think you were taking it this morning, probably for lack of time, but it's the case of Hodgson in the authorities bundle. Can I ask you just to look at that? It's a decision of the Employment Appeals Tribunal at page 120. Paragraph 27. Not actually the bit with the sidebar, but the other bit. The lay members are of the view it did not need a high degree of specificity in these documents for the claimant to have realised that if he were to behave as he did, he was putting himself at risk of dismissal. This is not a simple case of lateness, nor of taking an extra cigarette break. The conduct had to be taken in the round and involved a reckless decision to take a cigarette break, which he implicitly accepted he ought not to have taken, which not only resulted in his arrival at the aircraft late, as he was eventually to admit, he changed his story a few times, but without the necessary equipment, meaning he had to go to another stand to collect it. And then at 29, our unanimous view is it was entirely reasonable to regard the conduct in this case taken overall as conduct sufficiently grave to justify immediate dismissal and known to the claimant to be such. And then 30, the next question is whether dismissal was in the range of reasonable responses. In that regard, it's no more open for tribunal substituted for our view, etc. And then within the italicised words, we note in endorsing the dismissal, following the hearing, the appeal officer said...
So where are you?
Sorry, my lord, I'm going too fast. Next page, do you see some smaller print? So end of that first paragraph of smaller print. Furthermore, at no part in this process have you accepted any wrongdoing of your part and have sought to create false justifications. Had you admitted to an error and given reassurance, that there would be no future repetition. I may have had some scope to substitute a final warning. And my learned friend and their Skeleton relied on that, but they completely missed the point. That he'd already been convicted, rightly they say, both in the tribunal and the appeal tribunal, of offences of gross misconduct. And the next question was, had he done anything to mitigate? And the answer was quite the contrary. He lied about it and not suggested he wouldn't do it again.
But the association between attitude and mitigation is, in a sense, accidental. It can be the way it's deployed, but you could have nothing that you headed mitigation. You say, here are the facts. By themselves, I don't consider them sufficiently serious to justify dismissal, ignore any mitigation. But because of your lack of insight and the consequences that I can't trust you not to do the same thing again, I will dismiss you. Then it's not really a mitigation point at all. But in cases like this, it comes up because tribunals quite naturally say, well, if you had expressed contrition and understanding, I would have regarded that as mitigation.
Yes, I think it's mitigation, oblique stroke, or lack of it.
Yes. Yeah, I'm just...
But not aggravation.
Well, I agree.
I mean, it could be... It's just another factor, isn't it? I mean...
If you're in the category of gross misconduct, I accept an employer is entitled to take into account, for instance, length of service. You could argue, my friend says, either way, it could be against.
That's how it was deployed.
Or it could be
here
in your favour. Clean disciplinary record, obviously in your favour. Remorse, presumably in your favour, if at all. And demonstrating that you have understood you are not to do the same thing again. Important mitigation. Or lack of.
I'm just trying to see how to categorise my mind. It's not, it often overlap or could be characterised as mitigation or lack of mitigation point. Anyway, but it's not.
So just to summarise before turning to the next ground, in relation to, I think it was 1.3, the ground, because the respondent was wrong to characterise his conduct as gross misconduct, for all the reasons given by us and by the AT, and because the judge was wrong to accept that characterisation, Mr. Hewston's subsequent attitude, which we say is entirely unobjectionable in itself, he stated truthfully what his view had been and why at the time, and then stated that he would not commit the same category of conduct again. His subsequent attitude could not translate an inevitably unfair dismissal into a fair one. So ground 2 is referred to somewhat loosely as procedural failings, and I accept there is some cogency in so describing them, but we would say in relation to the failure to provide documents that the unfairness of those procedural failings was substantive. They provided, both for the Employment Appeals Tribunal and we say with respect they should for you too, an independent reason why the dismissal must be held to be unfair, albeit we accept that when it comes to remedy, the way the Employment Tribunal deals with it may be different.
Oh, sorry.
Does that mean?
Are you saying that if the unfairness is purely procedural, at the remedy stage there might be poultry arguments?
Exactly. Sorry, I should have made that more clear.
No, in a sense, from that forensic point of view, round 1 is by far the more important of the two in terms of its consequences.
It may well be, yes. I mean, I agree that ground 1 gives no Polky argument. Ground 2 opens up Polky argument.
Yeah. So if ground 1, I'm not suggesting that we would do it this way, but just so I get it clear in my head, if you win on ground 1, that is to say, if we say the AT was right to find the Employment Tribunal was flawed on that substantive question, it doesn't really matter. Ground 2,
not in practice.
The tribunal's order would be just the same.
I agree.
Namely that the appeal could be allowed, finding your unfair dismissal substituted, and the matter go back.
The practical value of ground 2 evaporates with ground 1, but obviously it's important.
No, in principle you might lose on ground 2, ground 1, in which case you would you want to win on
but
ground
also,
2.
even if we win on ground 1, and I accept that your implication, my lord, is that you would do this anyway, but we would invite you to decide ground 2 because it's a question of importance for the parties whether or not there was a significant deficiency in these respects.
And sorry to interrupt, it would feed into the Polky arguments that were going to be dealt with at the Employment Tribunal in any event, because we would still have to deal with.
Well, on ground 1, if you lose on ground 1, Mr. Allen, poultry isn't in play, is it?
Well, there's contribution.
I don't want to have the argument. Contrib is in principle.
Sorry,
poultry isn't.
I was sort of using Polky as a sort of summary for all of the remedies.
Oh, I see.
But
yes. No,
I shouldn't have done that. I also shouldn't be speaking in the middle of Mr. Siegel's
well,
submissions.
you're both
it's the
very
second
civilised
time
with
I've
each
done
other.
this, and he didn't interrupt me. I'm very sorry to him.
No, that's fine. It's actually been helpful to me. So what it boils down to is that at the remedy hearing, on ground 1, I'm not saying anything that hasn't already been said, one of the judgments, contrib may be an issue, depends obviously if it's run, but it may be. Poultry won't be, but on ground 2, poultry could be.
Yes.
Yeah, okay.
I won't waste time by explaining why contrib won't be, but let's leave it that
No,
it's going to be argued that it might be.
We're not going, we've got enough to decide without deciding that. But.
The document, and that is the most important of the 3 issues. There were 3 documents, only 3, in the case, internally that is. The school's statement of the complaint, the pupil's account, and the Lado report. All of those documents were before the dismissing manager. All of them were referred to in her dismissal letter, and none of them was provided to the claimant. And as the Employment Appeals Tribunal said, that is axiomatically unfair.
You're going to deal with the point that they were dealt with in the appeal.
We've cited one of many cases. It's going to be short for me to take you to it. So the authorities bundle is a case of, I think it's pronounced Lewis, but I'm not sure, at 128. Decision of the Employment Appeal Tribunal, 1990, the President and the lay members. And one sees from paragraph 4, which begins at the bottom of that second column of the first page, that Mr. Lewis was told his employers had 2 statements about his involvement. And over on the next page, Mr. Lewis said he would like to know what the statements said. And then a few lines down, he was refused a sight of the statements. All he was told about them was that they had said he was involved. And then at paragraph 7, which at the bottom of the same column on that page, about halfway down that part of the paragraph, there's a sentence beginning, they rely, secondly, and more importantly, say the tribunal, on 2 written statements. They go on to look at the statements, to comment on the discrepancy and the accuracy, and they go on. Our next finding is that the conduct of both the appeal proceedings and the previous investigation were not satisfactory, and that the applicant was never given a copy of the statements on which the respondents relied, nor told the names of the people making them, although he asked for them. This made it more difficult for him to answer charges against him. And then at the top of the next column, 2 statements, more importantly, neither of the contents of which had been given to him, although he'd asked for them. He didn't know the contents. All he knew were very, very broad allegations contained in them. I take you to those because we say those are pretty similar facts here. So you remember the judge said, well, he knew what the allegations were in broad terms. Paragraph 11 is the statement of principle. Next page, first column. Beginning that paragraph, it seems there must be rare cases indeed for the procedures to be fair, where statements which have been given in writing and upon which in essence the employer is going to rely almost entirely, and that's this case, an employer should not have cited them, although she should not be told very clearly exactly what is in them or possibly have them read to them. And a few lines down between the bars, the essence of the case, the main substance of the case is contained in the 2 statements which the employee was asked to see and which he was refused and upon which substantial reliance is placed. Then prima facie, it seems to be unfair. Now, the unfairness in this case, this is why I say it's not just procedural, was real. So start with the school's complaint. The school's complaint, which was provided just before the appeal, after he prepared his grounds of appeal, exaggerated what the pupil had said. The AT described it as glossing the child's words. That's at paragraph 79. But the dismissing manager relied on those exaggerated counts twice in the letter of dismissal, despite having the actual pupil's complaint in front of her. So can we just quickly do a compare and contrast? If you go to the supplementary bundle at page 3. That's the pupil's complaint. Shoulder and head, and then the key words, I didn't really feel that comfortable when he was touching me. Remember those words. Compare that with page 44.
Sorry, I've seen this. I just haven't got it. Where is the child's summary?
3, my lord, page 3.
Oh, page 3.
This is actually.
Oh yes, of course.
This is written by the student according to the tick on the box.
I believe it
Do you
is.
understand it?
One can infer from the spelling probably
Yeah.
it was not written by a master, at least at one point.
I'm not sure that's a safe inference, but then at page 44, This is within the dismissal letter. Third paragraph down. I asked you to reflect on the fact that the school have advised that the student expressed feelings that his personal space had been invaded and that he was extremely uncomfortable being touched by a stranger directly on his skin and hair. Now, bluntly, that should not have been in the dismissal letter. And it wouldn't have been if he had been given the opportunity to see the two documents. It's repeated on the next page.
Sorry, what page are we in?
So now we were on 44, my lord.
Thank you.
Third para down. We're now going to 45, second para from the bottom. The last few lines of the paragraph that begins, I must stress, the last few lines are, I'm convinced that touching his face caused the student to feel uncomfortable, and the schools reported that he felt his personal space had been invaded and was extremely uncomfortable being touched by a stranger. And my learned friend began, I might think oddly, but in a sense we were pleased that he did, because it gives us an opportunity to respond with what actually happened in this case. And these nuances are important. They're certainly important to my client, given his recollection of the event. If you go to page 7 of the same bundle, in the sort of box beginning at the halfway point, about 8 lines into that box, there was a lad that was soaked through. I said, look at the state of your soak through. I brushed a drop of rain off from his forehead. I asked him if he was okay. He said, yeah. I then carried on with the inspection. And then at 8, the next page, this is what he told the disciplinary officer. First box with AH on page 8. I made sure I had eye contact with the child before I wiped the rain off from his forehead. I asked if he was okay. I didn't say, is it okay, if I wiped the rain from his forehead.
So, sorry, where are we again?
8.
Yeah, I've got it now, yeah.
And there was no disengagement. The gesture was done in front of his peers. And then at the bottom of 9, next page, he specifically asked, have we a complaint from the child? If we have, we haven't been told about it. We're not aware of a complaint from the child. Tell us about it, please. We've had a complaint from the provider. And everything that the claimant says here is consistent with what he said in cross-examination. My learned friend took you to page 22 of this bundle, and with what the tribunal, with what my learned friend's cross-examination reveals, but contrast it with core bundle, page 140.
Do you mean page 140, sorry.
Core bundle, page 140 within the tribunal decision. Paragraph 47. It was a touch on the head and the forehead and on the face of the child, which they can only have got from what school had. From what Ofsted.
Sorry, I'm being to say which paragraph?
The end of 47.
Yeah, we've already seen. Yeah.
Yeah. And to compound matters, if you go back to the supplementary bundle, you may still have it open at page 9. About 7 boxes up from the bottom, there's a longish AH set of answers. There's 2 paragraphs. The second paragraph, I feel that any of my actions knocks that confidence. I feel the school's looking to blame the inspector on something. It's been a difficult school. I've been there 3 times. I know of an array of complaints being made about previous inspectors from that school. And then top of the next page, I think the school's looking for a reason to pick on an inspector. I might be wrong. It wasn't. That suggestion that he has made formed part of the criticism of him by the dismissing officer. Certainly the combination of the school's complaints, as you now know, ranging much more widely than his conduct, very serious allegations of race discrimination, and the fact of the school's complaint demonstrably exaggerating the pupil's account, if that had been known, if one of us was representing Mr. Hewston at that disciplinary hearing, we would have made some, I hope, compelling submissions on that issue. As it was, he was left cast in the role of someone who's propounding some wild conspiracy theory. The Lado report, twice in the dismissal letter, suggests that the seriousness of his conduct can be judged in part by the fact that the referral to Lado was made. Won't take them, but they're at pages 44 and 46. Again, to deprive him or his representative of the opportunity to say in response, but the Lado's response shows they didn't consider the conduct complained of by the school to be particularly serious. That, as the Employment Appeals Tribunal observed, that failure to give him that opportunity was axiomatically unfair in the circumstance. And if one goes to page 138 within the Tribunal's decision in the core bundle, the respondent relies on paragraph 36. And in particular, in the sentence 4 lines down, it is evident that the claimant was aware of the factual matrix in relation to the school's complaints and the concerns raised by the children. Now that's just obviously not right as regards the Lado report. And in respect of the other 2 documents, the 2 complaint documents, at its highest, it can only mean that he was aware he was being accused of touching a student on his head and shoulder as set out in disciplinary charges. He was aware of no other facts contained within or relating to any of those 3 documents. Now, to answer my Lord's question, a part of the unfairness in providing those documents might have been considered by the judge to have been, as is the vocabulary used in employment tribunal cases, cured on appeal. Because he was given a copy of the school's complaint and the Lado report before the hearing. One factual point, and then a more substantive point of analysis. The factual point is he was given those documents at a very late stage after he'd submitted his written grounds of appeal. But the more fundamental point is the judge never said anything of the sort. There is no finding in the tribunal's judgment that this matter was cured partly on appeal. In fact, putting it kindly, it's unclear from judge's reasons whether she realised the Lado report had been provided at the 11th hour to the claimant. Rather suggests she thought it hadn't. Certainly, that's the way I interpreted it, which is why my learned friend had helpfully to correct my understanding of what had happened at the appeals stage. In any event, a large part of the unfairness in not providing him with those documents before he was dismissed continued, we say, at the appeal stage. And that leaves me with the last point. I'm not going to pursue the exculpatory lines of inquiry point, not because I don't think we've made a decent point, but because, relatively speaking, we don't need it. The length of service. It's trite that length of service with a clean disciplinary record is a factor which is often properly taken into account in considering that statutory determination that the tribunal has to make under 98.4. And in an appropriate case, it has been found by the appeal courts that a tribunal has erred in law when it fails to consider such service or record as relevant. We've given 2 examples in our skeleton. They're not in the bundle. As I say, it's, I hope, trite. The cases are Spence and Spur. The one case we do take you to addresses a more nuanced point, which we say is germane here. Namely, where an employee's long and unblemished service was a key part of his mitigation, advanced during the disciplinary process, and the employer says without more, we have taken mitigation into account, deciding whether to dismiss. That's the Brito Babapule case. Can I take you to authorities bundle for the last time, I think, at page 125. Paragraph 25. which is actually, sorry, I beg your pardon. I don't need that. That's the exculpatory point. Please give me. Go to paragraph 38, which is on page 126. Fourth line down. Though the misconduct is gross, not this case, and dismissal almost inevitable, mitigating factors may be such that dismissal is not reasonable. And 7 or 8 lines down, the employer here had itself looked at the question of mitigation because it had said in its dismissal letter that having decided the allegations could be considered as gross misconduct, therefore it turned to consider mitigation. So very similar, if not identical, to this case. And then at paragraph 40, well, if you just read yourselves paragraph 40. And the 2 key points we take from that: the first sentence, it's not enough for the employer simply to say, I considered mitigation. And then 2 lines down, the second key point, the tribunal can't abdicate its function to that of the employer, square brackets, in such circumstances, a fortiora. So we say the parallels are clear. Go back to the core bundle, page 142, tribunal decision. Paragraph 58. Mitigation was considered. And that is not sufficient, all the more so given that it simply reflects an equally concise expression that you've already seen at page 45 of the supplementary bundle in the dismissal letter. And although my learned friend didn't have time to address you on this point...
So, sorry, which paragraph were you reading from?
58 of the tribunal decision, page 142, first line.
Yeah.
And then the reference to the dismissal letter,
Yeah.
supplementary 45. At the appeal stage, things got a whole lot worse. Because at the appeal stage, the employer purported to engage with this very important aspect of mitigation, but, as it were, discounted it because on a couple of occasions the claimant had not provided reports on time, which might, though in fact did not, have led to some rap over the knuckles for performance. So not a disciplinary issue at all. Finally then, very shortly, disposal. Nothing to say on Jaffrey. We do pray in aid of Justice Morris Kay in Burrell or Burrell, provided that the appeal tribunal is intellectually honest, it can be robust rather than timorous in implying the Jaffrey approach. And then the statistics, there is reason to believe it is robust. It seems that they remit in only half successful appeals. What did the Employment Appeal Tribunal say by way of explaining its decision not to remit? Core bundle 104. Paragraph 97. Picking it up, third line in. The tribunal failed to engage with whether the dismissal was unfair because the claimant was not fairly on notice that he might be dismissed for this specific conduct, and it was not inherently obvious that no such notice was needed. That is well-founded. Given that the specific incident was not found to have raised a safeguarding issue, etc., this is the bit my learned friend read out, but the respondent did not claim was not found to have a no-touch policy, and it was not disputed that there was no policy or guidance given in training. Had the tribunal applied the law to the particular facts found by it, it would have been bound to conclude that it was not fair to dismiss the claimant when he was not on fair notice. Now, my learned friend places a somewhat structurally odd interpretation on that. The final few words are the conclusion based on the proceeding. And we say an impeccable conclusion. It does not, as my learned friend suggested, leave out the question whether the claimant should have been aware. It addresses it head on in the sentence prior to the one, or sorry, part of the sentence prior to the part he read out. it was not inherently obvious that no such notice was needed. Then at 106, in respect of the other part of the decision not to remit, at paragraphs 103 to 104, 103, about 6 lines down, having been shown the documents, it's apparent to us how the school described the child's account, glossed the child's words. Had the claimant been provided with a copy, he would have had a fair chance to make direct submissions. As we've noted, he was not properly made aware of its existence prior to the tribunal litigation. The application of basic principles of natural justice should have led to the tribunal's conclusion the admission was unfair. And then in 104, final 4 lines, had the claimant had sight of at least the email from the ladder, he would have been enabled to make a submission about that to the dismissing officer, Mr. John, by reference to its contents. Any sensitive personal information.
So where are you reading from again?
Sorry, it's the last 4 lines of 104.
Oh, I see. I thought you'd read those already. No, maybe you hadn't. Okay.
I think I'd referred to them but not read them.
Okay. Well,
Again,
we have read them.
we consider it was an error to find. We say that in making those findings, the appeal tribunal relied solely on the facts found by the judge and on, as they put it, undisputed documents and other undisputed factual background and context. And the decision to remit, not to remit, we say was inevitable and correct. Those were submissions. I don't know whether you want a reply first or whether you'd like now, Petunia, to address you on.
Oh, yeah, well, yes, Mr. Kirk.
Yes.
Quite hear what Mrs. Eagle said, but I imagine this is about simply whether there is some case law, authoritative case law about how equity and the substantial merits of the case.
Yes, that is the point. My Lord's question, I believe, was whether the second strand of Section 98(4), namely B, the substantial merits of the case, really adds anything to the first, which talks about...
Yes, whether there's been any authority about that.
And the essential answer is it doesn't. It's all part of the same assessment of reasonableness. The leading authority is a judgment of this court in the case of Orr and Milton Keynes Council, which may have been the authority my Lord was thinking of.
I think it was.
The head note makes it clear that, and this is applying a dicta, very old dicta of Lord Simon in the well-known case of Davis and Atkins,
yes, that's
applying
right.
the old law. It makes it clear that, subject to the view of the Supreme Court, the provision in paragraph A of Section 98(4), the question of whether dismissal is fair or unfair shall be determined in accordance with equity and the substantial merits of the case, does not import any notion of a second consideration by an employment tribunal, in addition to the exercise encompassed by paragraph A, which is of course
no need, frankly, to go any further. So this isn't a major issue in the case. It was just to pin down or to remind me of what the authority was about exactly how it all works, because of the point
Yes.
been raised by my lord. You've done that. I'm most grateful. That is, it comes back to me. That is the authority I had in mind.
Thank you. Could you just give me the reference? I'm afraid. For those
Yes, it's
of us who don't have
it's
a background
Orr
in
and Milton
employment law.
Keynes Council 2011 Industrial Cases Report 704. I'd also perhaps it's dealt with in plenty of places within the judgment, but paragraph 63 of the judgment of Lord Morbick deals with it fairly nicely, and also adds that its purpose really is simply to make clear that an employment tribunal is not to take a technically or legalistic approach to the determination, and the task for the ET remains determining whether the employer acted reasonably in the sense it's been determined in decided cases, which of course we would say feeds into what is you've already been addressed on in the case of Newbound and the avoidance of a tick box exercise. But I'll send in all that.
Thank you, Mr. Coe. That's very useful. Yes, Ms. Allen.
My Lords, I have a few things to say, but I don't think it will take me very long to say most of them. There's one thing that might take a little bit longer. Just on that question of Orr, so Mr. Kirk and I were in fact emailing one another the same case. I think that his summary of it was impeccable, and I noted only that it was a majority decision on the main point of the Court of Appeal.
Lord Justice Sedley went the other way.
Lord Justice Sedley did, but on this point, whether equity and merits was another layer of test, they all agreed. So that was a happy circumstance. The first point that I wanted to come back on was the respondent's suggestion that when sorry, it was the claimant's suggestion that attitude can't transform non-gross misconduct conduct to gross misconduct, and that's an absolute statement that's made on the other side. I say that that isn't the case. Firstly, in this case, the respondent says that the original conduct was sufficient to amount to gross misconduct, but that wasn't all there was. In this case, the conduct and the claimant's attitude towards it are indivisible. In this case, the subsequent attitude colours the employer's view of the nature of the conduct itself. And I do say that the subsequent attitude was able to move the employer along the spectrum more firmly into the territory of a band of reasonable responses, fair dismissal. And I say that in cases involving professional judgment, it is nearly always going to be necessary to look at the employee's attitude towards their own conduct to understand whether the employee strayed so far outside the required standard to result in a loss of trust and confidence. And professionals working with children that they don't know must be trusted by their employer to adhere to particularly high standards of professional conduct. And I would encourage your lordships to look at the appeal outcome letter at supplementary page 54 when considering this point, because there was a subsequent consideration of these points upon appeal. And lastly, on this point, in an unfair dismissal case, strictly speaking, what the tribunal's looking at is misconduct and the band of reasonable responses. We mustn't get too seduced into this idea of gross misconduct and summary dismissal, which is a wrongful dismissal.
Summary dismissal is clearly irrelevant. Gross misconduct, well, it doesn't appear in the statute.
The statute just talks about conduct. So it's a conduct dismissal. We don't. Everyone agrees on that. And then we're just looking at the test, whether it's in the statute or whether you applied a band of reasonable responses. It is possible. Now, I don't suggest this is that case, because I've still got a whole wrongful dismissal case to re-argue back at first instance, whatever the result of this court's decision. But it is possible to have a fair dismissal, which is also a wrongful dismissal, just as it's fair to have it the other way around. Yes. And these things happen all the time in the tribunals. So that was my point in relation to that matter. Another matter on which I wanted to come back very briefly was reference to lay members at the Employment Appeal Tribunal.
Yes.
So for a long time now, in the Employment Tribunal, an ordinary unfair dismissal case has been heard by a judge sitting alone. That's all about to change. From the 29th of October 2024, lay members are going to sit in the Employment Tribunal more commonly in cases in which questions of reasonableness come up.
Can I just ask two questions about that? One was the current position, and the position obviously therefore as it was in 2021, that they couldn't sit, or merely that as it were, a special reason had to be identified for some.
The default option was that they wouldn't sit.
Yeah,
they could sit. There's always a means of.
And this I think is just out of curiosity. What has brought about the change you're about to mention? Is it legislative?
There's a new presidential direction coming from the Scottish and English and Welsh presidents of the tribunal, which will be enforced from the 29th of October. It has been sent out.
You needn't send it more.
It's been sent out in draft and all that sort of thing.
Yes, I see. Fine.
And lay members are more likely to sit in this sort of case, and they're in fact less likely to sit in the sort of multi-week discrimination cases in which perhaps their utility has been judged to have been less than in these industrial
Okay,
work.
well, that's very interesting. How does it feed into what happened here?
The reason that I say it is in relation to this, I say, quite dangerous suggestion that you should give weight to the specific expertise of Professor Rowland in the Employment Appeals Tribunal. I'm sure that Professor Rowland is an extremely distinguished person. I don't really know anything about him, but Professor Rowland's presence cannot mean that he is better placed to decide an issue than someone who has had all of the
I
evidence.
am responsible for introducing this, though I discover that Mr. Siegel said he was going to introduce it anyway, so I don't feel so bad. I personally, I see the force of that. But there are two separate questions. There is it relevant, and if so, in what way, that the EAT sat with lay members at all? And secondly, is it relevant to consider the particular expertise of those lay members, or to attach legal weight to it, to which I don't take much persuading. We can't get into an invidious situation in which we...
Yes. So the answer to question 2 is definitely no. The answer to question 1 is I don't actually know why the EAT sat on this case with lay members. We were simply informed. We did actually object to one of the lay members who had some involvement with Ofsted. I can't remember what it was, and that lay member didn't sit, and another one sat instead. More than that,
I'm told, in fact, that there was an issue, not an issue, a question raised on whether you objected to Professor Rowland. Maybe Mr. Siegel misremembered.
I can't remember, but we objected to one person, and that person was removed. I mean, we weren't.
Oh, I see.
It wasn't that person. It wasn't him.
That's okay. It doesn't. We needn't. We're not going to go into this unless my lord speak out to the contrary. You won't find us either attaching specific weight to Professor Rowland's expertise, or saying anything about it in the judgment which might suggest that we could have done or should have done. But the fact of there being lay members at all is possibly relevant, isn't it?
Well, it can't be, because the 3 members of the Employment Appeal Tribunal, all no doubt distinguished and experienced in their own way, did not see all of the evidence. And the most important thing that they didn't see is that they didn't see the claimant giving evidence.
No. And that's a point about that's a point about the EAT generally. But on matters that doesn't mean that on matters which properly the EAT could form a view about, the fact that they were 3 people, including 2 lay members, isn't that it's a point you quite often see made, but nobody ever works out exactly why it's relevant in discussing the weight of authority.
Well, I'm sure they were of great assistance. I'm sure they were of great assistance to His Honour Judge Auerbach, who's himself distinguished. But no greater weight, I say, should be given in this case on the issues that this tribunal, particularly on a substitution point, where the important thing is, did these people have all of the evidence? Did they see the claimant give his evidence? Because everyone who saw the claimant, internally or the judge externally, found for the respondent. The third point relates to what I said earlier, and it came up again in my learned friend's submissions. I said that the Employment Appeal Tribunal found that she should have known better when discussing the RBS case. I'm very grateful to Mr. Livingston for pointing out that my paraphrase was actually with reference to paragraph 94 at page 49 of the authorities bundle, where the Employment Appeal Tribunal said, the claimant was a senior employee who was or should have been aware of the gravity of the breaches of duty, and in those circumstances it was unnecessary to specifically warn her of the consequences of what she already knew, or should probably have known that the respondent would regard the breaches of duty as serious. I was wrong to paraphrase it, and I got caught up in my own error. So, thank you to Mr. Livingston for...
Grateful to Mr. Livingston. No, I don't think we were judging you on that, Mr. Allen.
It was suggested in relation to this point, which is a rather awkward point for me, that the Employment Appeal Tribunal has recorded that I
divorced the issues of conduct and attitude. It's embarrassing for me, but I say that I couldn't have presented the respondent's case differently to the way that the respondent has recorded its reason for dismissing the claimant in the dismissal letter. It is correctly summarised in the Employment Appeals Tribunal's judgment at paragraph 40, which is page 90 of your core bundle. The dismissal letter at supplementary bundle page 46 refers to a grave error of judgment and your lack of contrition or remorse in the closing section of the dismissal letter. And the Employment Tribunal at paragraph 73 made a finding that the claimant touched the child and did not see his actions as inappropriate. It's all and rather than or divisible.
Yeah.
My next point, and I'm more than halfway through the points now, is that it was suggested that maybe a useful analogy might be that someone tells an unobjectionable joke, or a joke that was unobjectionable 20 years ago, perhaps misogynist, perhaps about an Irishman, now inappropriate, and it would be wrong if the policy said that anyone would be dismissed summarily for a joke. Well, it all depends on context, doesn't it? What is the workplace? Is it a factory floor? Is it the male British ambassador to Ireland addressing a group of Irish nuns? That could put it into an entirely different context when the misogyny and the jokes about the Irish come up. And the context here, I know I've banged on about this possibly too much, but the context here is that an important person in a position of authority who was an inspector expected to uphold the highest standards acted in a way in which left his employer unable to be confident and trust excuse me, that he could be sent into a school again. In a similar discussion, my learned friend made the point that what happened wasn't in the street. What the respondent says is that it was reasonable for it to think it makes it much worse that what the claimant did was done whilst on his official duty in a position of importance and authority and power and so forth in the way that I've already laboured. It was said by my learned friend that I had sought to distance the employment judge and her understanding from that of the Lado, who had reached a view without evidence. And he said, I don't know what the evidence is supposed to be. Well, the evidence is the claimant demonstrating his attitude in the internal process, and everyone who saw him found against the claimant. Only those considering the matter at one remove from this actual claimant pointed the other way. I think, my lords, those are all of the points on which I wish to come back, but I do want to just turn to Mr. Livingston because he had a part to play in the submissions, and he may, of course, wish to come back.
It's perfectly appropriate.
Thank you very much, my lord.
Right, well, the first thing I want to say is that we've heard excellent arguments for which we're grateful, both for those who actually delivered them and those behind them who no doubt contributed. Both sides of the argument have been put extremely cogently and well. Second thing is we now need to rise and consider where we take it from here. So we may be in a few minutes, but don't go away, certainly don't go too far.
All right.
as you said, people have been doing that from time to time for a long time now.
The fact that they lost.
Yeah, is it not just that they're going to tell us how long it might take or something like that?
It would be very broad. Just say you'll get it when you get it.
You might come back with 5 more questions for each of us.
No.
Well, he might watch it. It's not as if there's a great rush because everyone's waited now 5.5 years. Absolutely.
Streaming is not on.
Yes, we've only said very pleasant things. You fed me the line.
I just put the ball on the penalty spot. Not what it keeps up.
It's an immediately vivid image.
I remember that.
I don't think a British ambassador is an employee. I'm not sure they come in front of the, not on an unfair dismissal.
So it shows me you couldn't stay away. You're only going to come in the morning.
That's on the record.
Had to hear you, you know.
What was hard was to sort of make the points that I wanted to make. Capitalize highlighted while keeping it up in the around for a while. But if that's
This room.
This room's literally
So if you're going to try to make it useful, what's the feel like?
for him rather than although go through the twice. It makes just is that a particular feature? Like this room. Is a particular feature of that particular room.
Oh, it's got like a red tag and the red lightning. I actually didn't know. It's one of the.
It's on the other side as well. Do they work?
These ones. What would you use these buttons for?
So we never do it for not better. The ways it restrictions.
They're coming back.
About to.
Okay, everyone.
It's very nice.
Not entirely.
Tease.
You just have to go home. It's before the invention of the telephone. One of them, Chambers, isn't doing. But are you doing the big hearing on that, or there isn't a big hearing? Will some of them not fight on certain points? Some, if this one, that could take months to get a judgment, presumably. Maybe they've timetabled in the time. Is it lay members as well? See, I think that's the sort of case where there won't be any lay members. Which is the sort of thing where the new guidance is. Discrimination on disability. Yes, well, I think they are. Of course, you could have one reason for adjustment, 77 other. Of course, I mean, it might not come in, but the current idea is that it can force them. It's gone out for consultation. Well, that's not going to happen for Tuesday. So that camera points this way, but is there not another camera that points at that? Isn't it mainly pointing? It's swiveled round. Oh, I see. That's.
Well, as you'll appreciate, we're not in a position to deliver extemporary judgments in a case of this complexity and possibly of some wider significance. However, we are very conscious that this litigation relates to a dismissal that occurred almost 5 years ago and an employment tribunal decision about 3 years ago, and the process since that decision has not at all stages been as quick as it might be, and all that time the matter has been hanging over the claimant. That being so, we are prepared to say now that we propose to dismiss the appeal for reasons which we will give in writing in due course. Our present view is that there's no difficulty, no substantive difficulty about our making a formal order to that effect now, which will simply say the appeal is dismissed, the result of which will be that the EAT order stands, and I gather it's been agreed no order is for costs. But if there's some hidden complication about making the order now, we will hear counsel about that. Do you feel bounced, Mr. Allen? I don't think it's a very difficult point, but I can't see any reason why we can't make an order now.
No, my concern is simply in relation to any potential application for the matter to go further.
Yes.
That the time starts running for that when the reason judgment is received. Because if it doesn't, then it.
Are you sure that's the case? I've got a feeling it runs from the order.
Yeah, well, that's what's running through my mind, and that's my. So, I mean, at the moment, I don't know what the appetite is for doing that, and I don't have specific instructions as to what to do.
I wouldn't expect you to.
But if it ran from the date of the order, then it would be very difficult if I didn't have the reason.
Yes, we did actually give that some thought, and this is our view, but it doesn't necessarily mean you can't argue back. If you think that you may need, we don't have power to extend time ourselves for an appeal to the Supreme Court. I know that because this point has come up before. But they have power. If you have decided that you may wish to, or are likely to wish to, but of course can't make a definitive decision till you see the reasons, and certainly can't articulate any reasons till you see the reasons, then you would be well advised to make an appeal, make an application of a holding nature for an extension, saying that whatever it is, we're minded to appeal, there's a real possibility you might wish to appeal, we haven't got the reasons yet, will you please extend time till 14 days, whatever you care to ask for, after you've received the reasons. I can't guarantee that the Supreme Court will will say, of course. I must say, I should be amazed if they didn't.
Well, because that does rather leave matters open. In that case, I would therefore ask that you do not make an order until we receive your judgment.
Because of the risk.
Because of the risk, and because it's a slightly odd request for us to then make because we have nothing.
Well, I think it must be a situation they come across occasionally. It's not unknown for us to do what we've done now. It's not very common, but it's not. It happens.
I understand. That's what I'm asking for.
Yes, very well. The disadvantage is that everything has to wait. We will get on with the judgments as soon as possible, but we have a lot of work in this court. I can't say that we can give the reasons as quick. I can't say you'll get them next week, in which case this wouldn't be worth arguing about. The claimant has been waiting a long time for the next stage.
Yes.
Mr. Segal will have to just rise from members and decide what we do in the light of Mr. Allen's objection, which we understand, but we've got to decide what weight to give to it. Anything you want to feed in that we haven't already said?
I apprehend that your proposal is in order to enable the claimant to make an immediate application.
Sorry, can you speak up a little?
Sorry, is in order to enable the claimant to make an immediate application to the Employment Tribunal to have a remedies hearing listed.
Yes.
And
Well, that's what. Yes, I agree. If he's
Yes.
not going to do that, but he obviously, well, can't see why he wouldn't be doing that.
No, exactly. It seems to me that as long as there's an undertaking from the respondent, I'm trying to sort of see it from their point of view, although I think that, like my lord, the prospect of the Supreme Court refusing that holding application is nil. But even to cater for that possibility, we can still make an application, it seems to me, to the tribunal on the basis that this court has
Yes, I see.
said that the appeal will be upheld with order and reasons to follow, as long as the respondent doesn't take some pedantic point on the order not having yet been perfected.
Well, that ought to satisfy you, Mr. Allen. I mean, well, I suppose the risk the other side, but I think that's vanishingly small as well, is that the ET will say we won't do anything until we've had an order. But then they won't do that. And if they do, you can come back. But
I don't object to Mr. Siegel's proposal. It's
Very
very
well.
sensible. It will take a long time for the Employment Tribunal, given the
I understand there's no
dichotomy
risk,
with
I'm afraid, or risk is the wrong word. There's no possibility, I think, of it, even if you wrote to them tomorrow, getting it on this year, unless things have changed a lot since last time I heard about Employment Tribunal listing.
They're unlikely to list it before we know what the reasons are from the Court of Appeal, and therefore are able to take what they might do is to progress the administrative process.
Well, that's the point.
But
I,
that can
mean,
then
I
be
think
paused.
that was exactly what lay behind what Mr. Siegel suggested.
And I'm happy with that.
The way it works, I think, you two will know more about it now than I do, but in practical, you need to get a date into their diary, because it'll be X months from whenever you ask, and if it turns out to be, a couple of months from now, you're a couple of months later down the road. So you want to get them, but it won't actually be before the reasons are received. I'm not actually sure, though, that you will, and I see you'd like to have them, and you will have them, but not actually sure that our reasons will be relevant to anything that arises on the remedies issue, because what we effectively have done is upheld the order of the EAT in circumstances where there isn't a respondent's notice.
I'm sure that the Employment Tribunal that's dealing with the case will be reading with avid interest anything that the Court of Appeal have said at all in relation to
Of course they will. Everybody always reads our judgments. But yes, well, we needn't. We
seem to have arrived at
at
a solution.
You will do whatever is necessary simply to support what Mr. Siegel's solicitors will be saying to the ET, saying we now have the result. There isn't a formal order because the respondents didn't want to be prejudiced on the question of time to appeal to the Supreme Court, or if they choose to do that. But this is the equivalent of a substantive decision, and we've agreed, and the court has indicated that we should agree that the ET should get ahead with listing.
I think the respondent might, to be fair to the Employment Tribunal, they might add that they are considering whether to appeal the matter further.
Yes. I don't mind how it's worded, and I'm quite sure the two of you will write something that's appropriate. And I don't think it need be recorded as a formal undertaking. If something goes wrong, you can always apply it to the court. That being so, we will not make an order now, and then you won't be at... Well, sorry, I haven't asked my lords.
No. Whether we might have a draft. We can solve the problem before everyone goes away.
What draft now? Oh, yes. Yes. And I think this might look presentationally better. Could you both submit a draft order, which will be extremely short, and we will then indicate that we have no difficulty with it, but that we will not formally issue it for the reasons given. And that will enable you to say to the ET that an order has been agreed, but it just hasn't been made for this particular reason. So if, in the usual way, I forget now which of you would have the carriage of it, but between you, it's basically just to say appeal dismissed, no orders to cross, so it's not very difficult.
I'll be encouraging the winner to draft this 2-line order.
Mr. Signal's very busy, so. Then he does
Too busy to do that.
Very well. I repeat the thanks to counsel for a very well-argued case on both sides.
All rise, please.